Very good morning, students. Today's topic for discussion is, what would be the topic today? Let me guess. Today's topic is principles of res sub judice and res judicata, and also the bar to future suit. Now, before we enter into these three terms, one by one, we would try to understand what do we mean by the term res sub judice and what do we mean by the term res judicata, and whether this res sub judice and res judicata operate as a bar to further suit, that is to say, future suit in respect to this particular subject matter. Now, students, let us see what do we mean by the term res sub judice. This we call the same to be a stay of suit. इसे हम stay of suit भी बोलते हैं. Now, if we take into consideration the definition which has been, or the provision which has been provided under section 10 of CPC, we come to know that res sub judice means a stay of suit. Now, stay of suit, you know that a suit is going on and a court stays the suit. Now, court stays the suit, maybe suo moto or maybe on the application moved by any of the party. Now, it is important for us to know what are the situations wherein a suit may be stayed. But before going into these different situations, what is important for us to know one by one, what do we mean by the term res sub judice? While going through the definition which has been provided under CPC, which runs as follows. First, no court shall proceed with the trial of any suit in which the matter in issue is also directly and substantially in issue in previously instituted suit between the same parties, or between parties under whom they or any of them claim litigating under same title, where such a suit is pending in the same or any other court in India having a jurisdiction to grant the relief claimed, or in any court beyond the limit of India established or continued by the central government and having like jurisdiction, or before the Supreme Court. Now, student, this is such a big basically sentence. We have to understand, we must try to understand it by breaking it in 2 to 3 sentences. Firstly, on the basis of the reading which I have done, or the provision which has been provided under BAR Act, or whatever the book you are holding is, if you go through the section 10, you'll find to know that there are certain things which are actually important for the purposes of understanding res sub judice. Firstly, there are two institutions of suit. Two institution of suit means what? One, so there is a two time the suit has been instituted, one previously and later on the subsequently. These two suits have been instituted in the same court, or may be instituted in different courts having a competent jurisdiction to entertain the same. Now, we have already started the situation when we dealt with the concept of jurisdiction. We have already started the concept wherein the various different court may have a jurisdiction to entertain that particular matter, provided that particular matter comes within their particular pecuniary limitation. Some of the court are having a pecuniary limitation, some of them may not be having a pecuniary limitation. In that situation, the amount value, the limitless amount value is available for the purpose wherein the court may exercise its power or the authority to determine the issue between the parties. Here, likewise, different courts are having a jurisdiction to entertain this matter. On the basis of this particular principle, the parties have filed n number of litigations or have filed two or more litigations in different courts who are competent to try that particular matter. The litigation is between the same people. The litigation is for the same relief. The litigation arises out of the same cause of action. But there are two suits, one previously filed suit and later the subsequent filed suit. Previously filed suit is not yet decided by the court. Previously filed suit is not yet decided by the court, and subsequent suit has come before a court, or the other party or one of the party make this previous court know that this party has again filed a suit in the next court or in the other court, wherein the other court is also competent to try the matter. But because this particular matter are between the same parties asking same relief over the same subject matter, hence cannot be entertained by two different courts, because if entertained by two different courts, then in that case, after determination of the matter, that is to say, after passing of the decree, the question would come that whose decree would be made enforceable. And hence, in order to stop this confusion, it is always better that when an authority is already entertaining any matter, then in that case there is no need of the party to file separate suit in some different court asking same relief against the same party arising out of same cause of action. This is called as res sub judice. That is to say, previously filed the suit is pending. Another subsequent suit is filed by the party, maybe before this court only, or maybe before some another court who is having a competent jurisdiction. Then in that case, one of the suit need to be stayed. Now question arises, which suit would be stayed and which court is competent to stay the proceedings. So that is what we are going to see in this section in the coming slides, and we would try to understand this concept very clearly so that we would be in a position to differentiate it with the section 11, that is to say res judicata. Now students, let's proceed further. What is the nature and the scope of res sub judice? Because I have already given a meaning of the term res sub judice, I have already given you a background behind the res sub judice and what is the purpose of giving the res sub judice provision. Now let us see the nature and the scope of res sub judice, that is to say section 10. The court shall not proceed. It means what? Court is restrained from proceeding further if suppose these two conditions exist in any of the matter. Now what are these two conditions? First, the matter in issue is also directly and substantially in issue in previously instituted suit between the same parties. Now this itself says that action relating to res sub judice would be taken in the subsequent suit if suppose filed by the parties. जो भी स्टे है वो सब्सिक्वेंट कोर्ट देगा, सब्सिक्वेंट सूट रिस्ट्रिक्ट कर दिया जाएगा। ठीक है, तो उसके लिए कंडीशन क्या होना जरूरी है कि वॉट एवर द मैटर इज फाइल्ड इन द प्रीवियस सूट इन द प्रीवियस कोर्ट, वही सेम चीज अदर कोर्ट में भी डाली गई है, दूसरे कोर्ट में भी डाली गई है सब्सिक्वेंटली, बाद में। एंड वही चीज सब्सटेंशियली, डायरेक्टली और इनडायरेक्टली सब्सटेंशियली वही चीज उस पर्टिकुलर सब्जेक्ट मैटर में इन्वॉल्व है। तो यहाँ पे भी हमको एक बात पता चलती है, क्योंकि वर्ड प्रीवियसली इंस्टीट्यूटेड सूट हैज बीन यूज, इट मीन्स देर आर टू सूट्स, one previously instituted, second one is later instituted. The court in which the later suit is instituted, that particular court will not proceed will not proceed further in the matter if that court comes to know that the matter involved in the subsequent suit is directly and substantially in issue in previously instituted suit between the same parties, and that matter is pending before the court. It is not yet decided by the court, and hence the court shall not proceed further to entertain this particular matter. This type of stay which the court is granting, the subsequent court is granting the stay for entertainment of that particular subsequent suit, is nothing but a res sub judice under section 10 of CPC. Next point, what does next condition says? That previously instituted suit is pending for adjudication in the same or any other court in India. जो previously instituted suit है, that has to be actually filed for adjudication. Adjudication means what? Determination of the final rights between the parties. That is to say, whenever the decree would be passed, it would be giving a final determination of the parties, and the party would not be having any other grievance against each other if suppose a decree is sought by that particular party. Then in that case, and that previously instituted suit is actually filed before either the same court or any other court in India which is competent enough to entertain and adjudicate upon that particular matter. So these two important conditions need to be applicable if we want to apply the principles of res sub judice. So first condition is what? The matter in issue is also directly and substantially in issue in a previously instituted suit between the same parties, and second is the previous suit is pending for adjudication in the same or any other court in India. Now if we talk about what is the object, what is the object of this particular section 10, that is to say res sub judice, so we'll see that there are basically four objects of this particular section 10. Firstly, to avoid a parallel litigation that are similar in respect. Now to avoid a parallel litigation, as we have already discussed, both the courts are competent one, both the courts are having the matter before them, which are of same nature, same relief, parties are asking the same relief, and the parties too are actually the same, and the subject matter also arise out of the same cause of action. Then because one court is not bound by the opinion of the other court, and therefore there may be an scope wherein two parallel litigation may result into two different contradictory decrees. In those situations, which decree we would be following, or which decree would the party would be accepting, and this is the situation. And in order to avoid such kind of basically situation, to avoid two parallel litigation would always be a correct choice, and hence it is necessary that in order to restrain a party to file two parallel litigation, because institution of a suit cannot be actually restricted, but yes, entertainment of suit can always be restricted. So in order, not by making a party, it is, we are not obligatoring a party not to file a suit, but we are obligatoring over a court, the legislature is obligatoring over a court to entertain such kind of two parallel litigations which are in respect to the similar cause of action, subject matter also similar, and the relief which the parties are claiming is also a similar one. So then in that situation, one court is restrained or is refrained from entertaining that particular matter. Second one is to protect a person from multiplicity of the proceeding, because in order, suppose if I have a bad will against you, then in that case I may put you in multiple proceedings just for the purposes of mentally harassing you. In order to prevent a person from doing so and to protect a person from any such kind of multiplicity of the proceeding, this res sub judice has been operating as a useful tool. Next is to prevent the court of concurrent jurisdiction from simultaneously adjudicating upon two parallel litigations in respect of same cause of action and same subject matter and same relief. Concurrent jurisdiction means what? The court are having a equal jurisdiction. Suppose if you want to file a civil suit in two different civil courts, in two different civil courts, maybe of same ranking, or maybe one junior and the another the senior one. If we have already filed a suit in the junior civil court, then in that case we know that our subject value is, suppose for example, 2 lakh rupees and the civil court is having a power to entertain the same. We accordingly file a suit in the civil court, junior division civil court. But suppose if we have further filed a matter in a senior division is always higher than a junior division. The senior division court is also having a pecuniary limitation because the pecuniary limitation of the junior division gets merged in the senior division pecuniary limitation. So pecuniary limitation of the senior division suppose is up to 4 lakh rupees. Then in that case rupees 1 to 4 lakh rupees would be entertained by the senior division. In that case we would consider that both the civil courts are having a concurrent jurisdiction, wherein both the civil courts are having the power or the authority to entertain the matter filed before them. In that situation, we have to prevent the court of concurrent jurisdiction from simultaneously adjudicating upon the two parallel litigation in respect to the same cause of action, the same subject matter, and the same relief. And hence, because we cannot prevent the party from filing, so we can only what we can prevent the court by making a enactment in the legislation. We can only prevent the court, and therefore in the starting itself section 9 speaks about the sentence which starts with no court shall proceed. That is to say, we have obligated the court not to proceed or to prevent from being proceeding simultaneously and adjudicating upon a two parallel litigation which are in respect to the same cause and the same cause of action, the same subject matter, and the same relief. And the fourth object is to avoid a conflict of decision, because whatever the decision the court gives, there has to be there is to be a decision which can be legally operated, and hence in order to avoid a conflict in decisions, this res sub judice has proven to be a very helpful tool. So this is nothing but an object of res sub judice. Now, let us see when this provision is applied. When this provision of section 10 is applied, I have tried to bring a gist of this particular 9 to 10 sentences in these small sentence. Let us see, students. Two suits, one previously instituted and other subsequently instituted. This is the situation. The second situation is matter in second suit must be directly and substantially in issue in the first suit. Whatever the matter is there in the second suit must directly and substantially be also the issue in the first suit. Then previous suit must be pending in the court in which a subsequent suit is filed or in the other court in India. Already the previous suit must be pending and it should not be yet decided. And before a decision in the previous suit, we have filed a subsequent suit, maybe before the same court or maybe before any other court which is competent enough to entertain that particular matter. Then two suits between the same parties, same title, same capacity of the parties, and the competent court to try the matter. Now, when we are saying same capacity of the party, same capacity of the party means in the capacity of the plaintiff, in the capacity of the defendant. Both the parties must be plaintiff or defendant, like बिल्कुल वैसा ही जैसा कि प्रीवियसली इंस्टीट्यूटेड सूट में था. जो प्लेंटिफ था वही प्लेंटिफ सब्सिक्वेंट सूट में भी प्लेंटिफ है. जो पहले डिपेंडेंट था प्रीवियस सूट में वही सब्सिक्वेंट सूट में भी डिपेंडेंट है. सो इफ दैट इज द थिंग, देन इन दैट केस वी वुड से that the application of section 10 would be made operative. Then next is when the provision does not apply. There are certain things wherein the provision would not apply. The provision of res sub judice, the stay of suit, would not apply. Firstly, the conditions above are not satisfied. Whatever the conditions we have discussed in our earlier slides, if is not satisfied, then in that case the provision of section 10 would not apply. The second one is the provision apply only to the suits in civil proceedings and not to other proceeding. The principle of res sub judice is only available so far as the civil suits is concerned. It is not applied to the other proceedings. Can you give me any of the example? Like for example, no one can be tried or no one can be tried twice. है ना? A part of that, we have a provision under double under constitution We know Article 20 double jeopardy. A part of that, we also have a provision under Criminal Act. So, but so far as res sub judice is concerned, we do not use the word res sub judice in relation to those provisions, though they may be reflecting the one and the same thing. But word res sub judice need to be applied so far as the civil proceedings only, and it would not be applied to other proceedings. Next is one of the, and here other proceedings also means an execution proceeding, right? Now, one of the two proceedings must be in a, so one of the two proceedings must be in a suit. So both the suits must be having the same proceedings. Same proceedings in the sense, same plea, same defense, same parties, same title, same subject matter, same cause of action, same relief. That is what being asked in both the suits, and hence this particular thing is there, then in that case this provision would apply. But if it not there, then in that case it would not apply. One of these two proceedings must be in a सूट. ये जो सूट बेसिकली हमने दोनों भी फाइल किया है, यदि उनमें वो सूट है तो ही अप्लाई होगा, सूट नहीं है तो वो अप्लाई नहीं होगा. Then suit must be legally tenable. If the suit is not tenable, then in that case this particular provision would not apply to it. And if the suit is tenable, legally tenable, then in that case the provision of the res sub judice would be made applicable. Now, the which court shall entertain an application for stay and which suit shall be stayed. Now, कौन सा कोर्ट जो है वो हमारे एप्लीकेशन स्टे एप्लीकेशन को कंसिडर करते हुए स्टे लेके आएगा, और स्टे लेके आएगा तो भाई कौन सा सूट हमारा स्टे होगा, प्रीवियसली फाइल्ड सूट स्टे होगा या अभी जो हमने सब्सिक्वेंट सूट फाइल किया है वो स्टे होगा. So the stay application under this section may be presented in the court in which the second suit is pending. है ना. द स्टे एप्लीकेशन जो है वो इस सेक्शन के अंतर्गत हम कहाँ प्रेजेंट करेंगे, जहाँ पे हमने सेकंड सूट फाइल किया है, या सेकंड सूट हमने नहीं फाइल किया है, बेसिकली वो पेंडिंग है, वहाँ पे वी आर द डिफेंडेंट जो कि ऑब्जेक्ट करेगा इस बात को लेके. सो जहाँ पे सेकंड सूट पेंडिंग है उस कोर्ट में हम स्टे का एप्लीकेशन मूव करेंगे, एंड नॉट द कोर्ट ऑफ प्रीवियस सूट इन विच द सूट इज पेंडिंग. सेकेंड, इफ द कोर्ट इज satisfied that conditions of section 10 is satisfied, will stay the trial of the second suit. तो अगर कोर्ट जो है वो हमारे एप्लीकेशन में दिए हुए कंटेंट से सेटिस्फाई हो जाता है, देन इन दैट केस ओनली वो क्या करेगा, सेकेंड सूट के ट्रायल को स्टॉप कर देगा, स्टे कर देगा. This was held by the court in GSK Center and Hospital versus OP Care Private Limited. This is the case wherein the court, the Supreme Court decided that the court is satisfied that condition of section 10 is satisfied, then in that case what he would do, he would stop the trial of the second suit. So it is the second court judge before whom the application of res sub judice, that is to say stay of suit, need to be moved, and accordingly it would be the second court who is going to stop the proceedings. ठीक है. Now come to next, we have already discussed